We're going to get started, and those who are filtering back can join us in progress. But we've got a full afternoon, and we want to try to get it all in. And I figure my voice is good for about another 3/4 of an hour, so you either get me now or you don't get me at all. Laskin says he'd rather the latter. We're heading now to preparing discovery, and Tricia Jackson will be dealing with the actual discovery, and of course there's an overlap, but I'm talking about the physical process of sitting at your desk, dreaming about how you want to conduct this discovery, what questions you want to ask, what areas you want to cover, how do you go about it, and specifically I want to deal with techniques to save money. I want to talk not just how to do it, but how to do it fast and cheaply using precedents, because that's the message I've been trying to give you this morning, and I hope to give you this afternoon. It isn't just how to, but it's what techniques can you use to save money. I talked about getting your client to do as much as possible, getting work done at as low a level as possible, and we're talking about use of precedents. These aren't just precedents off the shelf in some precedent book. They're your own precedents. They're you stealing my precedents and inputting them into your machine and adapting them to your own purpose and forgetting to give me credit. And that's fine, that's what we're here for. But you can then pull it back off your machine, not out of some precedent book, which you've then got to input into your machine. So, as I say on page 1, when I'm preparing discovery, I spread out on the desk some of the documents that I've talked to you about in my earlier lecture and some that we're now going to talk about in this lecture. I've talked to you about the thrust, that little one-page thrust that I have, what are my main points in this case, then the longer lists of issues, factual issues, legal issues, the chronology, which again is the backbone of my case. And then 2 new documents that I'm going to turn to in this paper, the chapter headings precedent and the notice of examination precedent, initially. And then at the next go-around, after you've done your initial preparation, you then have to do the detailed preparation. You have to look at the pleadings, the affidavits of documents, the documents, any prior examinations and a précis of them, and your memos of law. But that's the next stage. I don't start that way. And I also, as I indicated earlier, also engage in a separate exercise, which is sitting there with a blank piece of paper and dreaming and just scribbling notes. And then I go back and see how that compares with my earlier scribbles. And often they're the same, but sometimes they're a little bit different, and that's the way you add ideas to your case. So you will have had those earlier documents, if you follow my system, the thrusts and the lists of issues and the chronology. But from the earlier time we were talking, from the initial interviews to today, when you're sitting at your desk preparing the discovery, they'll have gone through additional drafts. As more documents came in, they would all have been input, hopefully by your staff. You won't have spent too much of your docketed time doing that. So you want to review all that. And as you had a different grasp of the case, as you've interviewed witnesses and had a different view, you may have changed your thrust a bit and so on. So you're now looking at the current drafts of those documents, updated. And I can pull a lot of my discovery straight from those documents and these new documents. I personally write out my questions organized into chapters. Not everybody does it. I'm not saying you should do it, and you don't do it in every case. You can't do it in a $25,000 case, but you want at least an outline. You don't want to be married to your script. You want to have a script. I want to have a script, but then you've got to be able to move from it. You get an answer and you follow it up. You go down useful side streets, but you come back. You don't let the witness take you off down too many of those tangents unless they help you. If it's a good topic, you're hot on it, then forget the script, follow it up. And that's experience. Then you go back to your game plan. include in the paper my personal views upon the usefulness of discovery, and John's going to talk to you about that. I'm pro-discovery. I think you're negligent not to have discovery and not to have a careful discovery. And I think a lot of the criticism of discovery is unknowing. They just don't appreciate the use of discovery. Because of the stonewalling you sometimes run up against, vague pleadings and so on, you've got to tie down the pleadings, you've got to get additional documents, you've got to tie down conversations. How many times did you speak to my client? Have you told me everything you said in those conversations? And then some of the new stuff that was added in the 85 rules, names and addresses of persons having knowledge with a summary of the substance of their evidence, find out about insurance, experts, and, as I say at the top of page 3, eyeballing the opposite party. How is this person going to do in court as a witness? And talking about settlement. I mean, discovery is a natural place to talk about settlement. You both reviewed the file, you've both seen the opposite party, you're both there, one or more of the clients are there, and it's often a very convenient place to talk about discovery. So I use precedent chapter headings, and I've given you a couple of examples. If you take a look at page G9, and remember, this is only a draft, but it helps to start with a draft, even as an aide-memoire. I start with some standard areas at the beginning. Documents, I try to get the agreement as to documents at the beginning. Then the formal questions, address, and so on. If it's a corporation, there's the corporate pyramid, the interrelationship of the companies. The formal questions, the plaintiff's background to the extent it's relevant, experience, training, schooling. And then, if it's a land case, some of the history of the land, particulars of the land. Obviously, these questions are adapted to a particular case and won't apply to all the cases, but acquisition, size, appraisal, zoning, co-tenancies, visits to the property, and so on. Expropriation, all the negotiations with respect to the property. That's before the agreement. Then down to Chapter 13, negotiating for the agreement. All the negotiations, step by step, one by one. If it's admissible, if you've pleaded, if the pleadings raise issues that allow it. You can't ask any of those questions if the contract's not in dispute, but if there's allegations of fraud, misrepresentation, and so on. So if you want to ask those questions, you go back to Tom Heintzman's pleading lecture. You got to plead those issues that will allow you to ask those questions. You haven't, you can't. Then capacity, health, experts, Rule 31, I'll come back to that. Calendars, diaries, damages, both sides. Remember, have a checklist. Think about asking about both sides' damages, or if there's only one damage, the plaintiff. It isn't just counsel for the defense asking the plaintiff, it's counsel for the plaintiff asking the defendant, what do you know about my damages? Something which is sometimes forgotten. Documents, to the extent that they haven't been covered in the general agreement, specific documents you want to ask about. Pleadings, you will have covered one by one in your chapter headings, but a wrap-up chapter for the pleadings. And then, at the end, usually at the end for me, I have chapters for experts, witnesses in quotes, i.e. persons having knowledge, Rule 31.06, and insurance. If you're suing someone who's insured, a negligent lawyer or personal injury or whatever, you want to know what the policy is, the basic policy, the excess policy, how many other claims, what's the status, how much money is left for this claim. Now, there was a question until recently. You couldn't ask those additional questions, but the Seaway and Markle case decided that you could. I conducted that discovery. I asked those questions. We brought the motion for reattendance. The judge ruled that those were proper questions. How many claims, how many have been paid, what's the balance owing, and so on. And leave to appeal was refused by Mr. Justice Wright, which unfortunately is not reported. So if there's insurance, very important to ask about it. And I've been on discoveries with leading counsel who forgot to ask about insurance. Can happen to any of us. That's why a checklist is important. My checklist is in the form of precedent chapter headings. Each of these is a chapter. This chapter heading index is an index to the examination, and I have a separate page starting with each chapter, and then I've got questions under that, and it's important to remind your secretary to start a new page with each chapter, because you may want to change the order. You got to be flexible enough to switch around, to move around, and so on, and if each chapter is in a separate bundle of pages, you can always change the order. On some of these trickier ones, like insurance and names of persons having knowledge and experts, I paste the rule right into my notes of examination for that chapter. And if opposing counsel isn't familiar with the latest law and says, you can't ask that, rather than to get into a hassle of a motion for reattendance, I show them the rule. I say, here's the rule. It's a clearly proper question. It's going to affect costs if he maintains the objection. And you go to the master and say, look, he can't plead ignorance. Here's the rule. He wouldn't let me ask those questions. So my secretary gives me those chapter headings. And again, an experienced secretary will not only give you a precedent chapter heading, he or she will adapt it to your case with the names of your clients and other subject, depending on the ability of your secretary or your law clerk or whoever's helping you prepare the discovery. You can move to the next draft away from the precedent and be given an amended precedent that is partly adapted to your case. And I find it a hell of a lot easier, a real time saver, if I start with that precedent. And even in some cases, the standard questions, just taken off our machine that we've got there. Saves me time, saves the client money. Also, then I've given you the another one starting at G13 for a matrimonial case. Again, just a draft. You can't use this. You've got to adapt it. It's not going to apply to all cases, but I find it helpful to have that piece of paper on my desk when I'm trying to think of the areas I want to examine into. And then after that, the notice of examination. My secretary does the first draft of the notice of examination, and I have it on my desk when I'm preparing discovery. Number one, the precedent notice. Number two, again, if she's able, she'll adapt it. She'll have taken the precedent and she'll have added documents that I want, that she knows I want, and she'll put it into the precedent. So I've got, again, a pretty good draft to work with. And as I sit there at my desk preparing the examination, and I think of documents that I want the other side to bring to the examination, I write them in to the draft notice of examination. I never deliver a short pro forma notice of examination. I always want to be able to say to the opposing counsel on the discovery, I gave you notice I wanted those. I want to be able to say to the master on the motion for reattendance, I told them to bring those documents to discovery. They didn't even think about it. You'll often find cases where you can't get the documents before discovery, and the more you get before discovery, the better your discovery. Discovery can be abortive without production before discovery. You'll get a pro forma affidavit, you'll get half the documents. You can't prepare. Sure, you can, sometimes they'll come on discovery and they'll dump a file and you'll do it quickly. Ultimately, you'll ask for them on discovery. But you may need to speak to your client about them. Here's a letter you never heard about. Did you get the letter? What happened? You may need to consult an expert about some of the documents. You want to do all that before you walk into discovery and not get sandbagged. There may be some cases where you should move for production, further and better production, before discovery. I've done it. The court doesn't like it. They're often going to throw you out unless you can show there's a lot of stuff they just haven't given you. But I do get those orders where the master judge will say, there's obviously more stuff you've got to produce. Discovery will be abortive if you don't. Give it to them now. You send a long letter for further documents that you want. You know that there must be documents. You've got the counterpart, or your expert tells you, or an ex-employee of the opponent says, I was there, they've got all sorts of inter-office memos, or they forgot to look in that department, or they forgot to look in the Seattle office. And you write a letter. Look in the Seattle office, look in the engineering department, inter-office memos, and you send a long letter of further documents you want, further and better affidavit of documents you may or may not move. You try to get them before discovery. It certainly helps on discovery if you've written the letter and you've put them all into your notice of examination. So you've got as many documents as you can. You've got your precedents. You think, if you're plaintiff, about admissions that you want to read in. If you're defendant, you're going to be cross-examining on the transcript. If you're plaintiff, you're going to want some juicy answers that you can read in as part of your case. Formal admissions like ownership of the car, who was operating it. The collision occurred on a public highway in Ontario. At the top of page 5, I say, at that point, you've got to consider how much your client can afford for discovery. And you either do the short one, the medium, or the long one. Again, depending on your budget, on the amount in issue, on the complexity of the case, you may have to go to discovery with not much more than that. I think you want at least the chapter headings or list of issues, some sort of roadmap. I mean, I've seen a lot of counsel go into discovery without a single note, and they just conduct discovery from the top of their head because they've done it 500 times. Why would they have to prepare? And that can work in some cases. In a simple motor vehicle case, if you're very experienced. Most counsel want at least a list of issues, and I think you should have that. And it's easy. It's easy to have your preliminary list from the type of precedent I've given you. How much of the additional questions you actually prepare in advance, that depends on your budget. I find that the more time I spend preparing, the more useful questions, you can always think of questions, the more useful questions I think of. And I know there are examinations I've conducted that if I hadn't spent the extra few hours, there'd be vital questions that I wouldn't have thought of asking. Just the exercise of sitting down and thinking about the case tells you about important questions. Then the order of examination. You know all the things you want to ask. What order do you ask them in? I've given you my thoughts about your opening questions and your closing questions. Beyond that, you want to ask the easy questions at the beginning. You're not fooling anybody. The witness you're examining has been told, look out for that guy. He's going to try to trap you. I mean, you're walking into discovery with that sort of thing. But still, you can establish a rapport with the witness and get yes answers and try to get the easy answers and not ask controversial questions at the beginning. And if you're on a roll, keep going. But the tough ones, when you're putting to the misconduct to the witness, unless you've got a different game plan, unless you want to shake up the witness, you want to tend to leave those questions to the end. I've given you an example from Malcolm Robb, who was one of the greatest examiners in this province. He used to talk about islands, about surrounding key questions with innocuous ones. Always be prepared to escape. I actually build escapes into my script. When I'm in an area that I try to ask the question in the way the witness won't know where I'm going, I get a good answer and escape quickly somewhere else. Don't give the witness the chance to explain it away or so on. The donut surrounding the hole, that's not a good comparison, is it? It's the hole surrounding the donut I'm talking about. I usually deal with liability issues before damages. I believe it's essential to tie down allegations in pleadings, but I do it factually first. I see a lot of counsel go through the whole discovery, and then they come to the end of the discovery and they take the statement of claim and say, now, what facts do you rely on in support of paragraph 4? What facts do you rely on in support of paragraph 5? You can't do that. So you ask about the facts that are pleaded in paragraph 4, and then you say, have you now told me about all the facts in support of your allegation in paragraph 4? Are those all the facts, and so on? And I give you an example. If paragraph 6 alleges the contract was induced by fraud and misrepresentation, and paragraph 7 alleges the contract was unconscionable, 7 obviously flows from 6. It's a conclusion from 6. There won't be a lot more facts in support of 7 than were in support of 6. So with the fraud and misrepresentation, you want to get all the facts in support. When did you meet? Where did you meet? How often did you meet? Give me the dates. Who was there? Who said what? I mean, you want to tie down all those factual allegations in support of that. Was there any note or record? Note or record is the way note or other record is the way I phrase it, because you can have audio tapes now, videotapes, hidden cameras, and so on. And then, are those all the facts in support of paragraph 6? Are there any further facts in support of paragraph 7? At the time. So I prepare the examination, and then I go back and I make sure I insert the pleading references into the appropriate chapter, and then I've got a cleanup chapter at the end to cover any allegations in the pleading I've missed. So I do the first sweep that I've been telling you about, and then I go on to the next stage of preparation, which is checking the actual productions to see what I want to ask questions about. You want to make sure that you've inspected the opposing side's productions. You've either sent a clerk over or you've got copies. And if you haven't, you have them there because you're looking for different versions. Most of them will be the same version, but there could be different versions. Handwritten notes. If the opposing party has written handwritten notes on one of the documents, you want to see those notes. You want to ask questions about those notes. And you review your chronology. Have I asked about all the documents? Have I asked about all the key documents, all the key conversations, the pleadings? And then the cases, the review of law. Have I asked the questions in such a way that I've met the test in the cases? Have I asked the facts that the cases identify as being the constituent elements of the cause of action or defense? And then, can you get agreements to shorten proceedings? This is a trial technique, but consider it pre-trial as well. If you've got a lot of title documents, can you reach an agreement as to a title summary before discovery to avoid a lot of time on discovery? If you've got audio tapes, can you reach an agreement with the opposing counsel on a transcript of the tapes and not have to go through the tapes on discovery? So I've got the chapter heading, I've got the index to the chapter headings, I've got each chapter, tab them, put them in a ring binder, which means you can open it up and change the order at any stage. If there are multiple counsel and you're examining second or later, then you've got to be, I still do the same work, but then you've got to be pretty quick during the breaks to tick off what's been covered so you're only asking supplementary questions. Consider a document book to bring on discovery, to put the documents as a whole as one document. And then settlement, prepare settlement in preparing discovery. Know your case, no liability, no damages. Consider taking an offer, consider taking minutes of settlement. Prepare yourself to talk settlement while you're there as part of your discovery preparation. And then finally, a checklist. I have found myself in court on a motion without any paper. I found myself on discovery with my beautiful script of questions and no blank pads. It happens. It happens to all of us. It's going to happen to you. It's going to happen to me again. So I have a checklist. I have a checklist I take on motions to trials. I have a discovery checklist. I've given you a copy at the end at page 19. And I recommend that you pull it out, and the morning that you're walking over to discovery, just run through it to see, have I got enough pens? Do I want to take Post-it tabs? All the little easy stuff that it's just too easy to forget. Okay, that's it on preparing discovery, and now Patricia Jackson will tell us how to actually conduct it. Patricia, one of our leading counsel and on the way up, whose voice is in better shape than mine.
I'm on my way up now, and I'm about to be on my way down. I'm now on my way down. And in fact, that's a little bit what I'd like to say to you by way of overview about the discovery process. I was here at the very end of the proceedings this morning, so I understand that this is a theme that you've heard some reference to before, but I think it's important when you think about conducting discovery to think about what it is discovery is about and what we're engaged in when we conduct a discovery. And I look at that a little bit from the perspective of what I have observed in the now almost 14 years that I've been practicing. And I think discovery in the early years was on its way up, and now as a tool it may be on its way down. What I mean by that is when I first started practicing, or as an articling student, I often went along with more senior lawyers who seemed to be able to conduct an effective discovery in many cases, not always, in 2 or 3 hours or a day. And in the early years of my practice, I then sometimes spent a lot of time on motions, as did we all, on interlocutory matters arising from discovery. And we, with great fervor, went off and said, it's right that you should be able to go and ask not only what this person knows, but what everybody who this person ever knew knows about this case, and we won that battle. And it's right that you should be able to say, tell me not only what you know about this case today, but anything you're going to learn between today and trial. And I actually took that battle on up to the divisional court, and I'm embarrassed to say I succeeded. I'm embarrassed because now it's been incorporated in the rules, and I am the object, and my clients are the object of this burden, of this increasing burden of the obligation for continuing discovery. The obligation that grew out of that to go through an increasing burden of sort of producing hundreds of thousands, in some cases literally that I'm aware of, hundreds of thousands of documents, and then the discovery question that emerged from that, tell me out of all of these documents which ones you rely on in support of paragraph 1. And that is a proper question, we're now told. And then the judges got computeritis, and you have to, in your productions, identify every single document on the basis that every single page can be computer inputted without further effort. And all of those things made sense at the time, and in context, they still do. But the process, in my view, and I think I sense the view of some others that you've heard from today, is now out of control. And I think very much to the detriment of each of us and our clients as we head into the discovery process. So that I think, as I look at this heading, conducting fast and cheap discoveries, the message is, I think, fundamentally in each case, to gear your discovery to what you need in that case, and not to ask every question you're entitled to ask, and not to conduct the perfect discovery according to all of the rules, but the discovery that you need to conduct for the purposes of the particular case that you have to meet. I think we, quite apart from the fact that that produces a more cost-effective result for your client, I think we should all be aware that this process, which has gone out of control, is, I think, going to be the subject of increasing judicial scrutiny, and we will all, I hope, be made to conduct more effective discoveries. And so those of you that have thought about this in advance and focused your discovery efforts accordingly will be that much further ahead. But we're already seeing it, I think, in some of the decisions that Eleanor Cronk referred to this morning, where judges have commented adversely on the never-ending discovery process. The Rules Committee is currently revisiting the question of whether the broad production responsibilities that now lie on parties to an action are appropriate in every case. Those of you who, particularly in complex case management cases, who are regularly meeting with judges will know that they are striving to refashion this process so that some of it can be done in writing, some of it by representative discovery, and some of it just dispensed with altogether. Equally, I think, as we look at the new class action legislation, there's a prospect there for seeing the right, if you're the examining party, to discover every potential person in the class collapsed into a prima facie right to examine one person in the class. All of these things are, I think, probably an appropriate response to this Frankensteinian discovery process that has developed over the last few years, but it emphasizes the need that all of us will have to confront as we go forward to really think about what it is we want to achieve on discovery and how best to achieve it. I think it's interesting. I have observed, as I've practiced over the last few years, that a lot of throughout this process where discovery has kind of been burgeoning into situations, I certainly have seen some where discovery has gone on for over 100 days. Even in those circumstances and even in those times, some of the best lawyers, senior counsel, names we'd all know well and admire, can still do it in half a day or 2 days. And it's important to keep that in mind. If they think it's probably not necessary, and they still keep winning cases, it's probably not necessary, at least in a lot of cases. In some, it certainly is necessary to conduct the kind of discovery that does go on. I think it's useful, and I'm indebted to Ian Outerbridge for describing this in a letter to Harvey Bliss, which Harvey sent on to me, as the process of going in like a vacuum cleaner and an obsession to vacuum up every single piece of lint in the room. And if you think about it, and think, for example, that your assignment on a discovery is like solving a murder, and you're going to go into the murder room, and you've been told you have a day in which to examine the murder room, or a limited budget. And you know, because you've thought about your case ahead of time, as you should have done, and developed a theory of your case, you know that you're almost certainly going to see the dead victim in the middle of the room. And you understand from your pre-discovery investigations he's going to have a knife in his chest. And as a result, you've developed the theory of your case that this man was murdered with a knife. Now, it's a rather simplistic analogy, but you could take two approaches. You can go in and say, now, first of all, I want to very carefully remove the knife and put it in a plastic bag. I want to observe exactly what's around the body and record that. And there are key areas where I want to take fingerprints. And then I want to make sure that my theory isn't totally wrong. I want to go and look and see that there isn't a gun somewhere else or a spear in the corner. That's one approach. That's what I would characterize as the focused approach to discovery. Do what you need to do. The other approach is, I don't need to know anything about this case. I'll learn about it on discovery. And you go in with your vacuum cleaner and you vacuum up everything in the room. Now, one problem is your half day may be over and you may not have yet got anywhere near the body. The other problem is that even if you succeed in vacuuming everything up, the knife is lost with the lint, is lost with the fingerprints, and what are you going to make of it all? All of which, I mean, the analogy, if you want to pursue it very far, of course, breaks down enormously, but it struck me as illustrative of the importance of doing some advanced preparation and thinking about what it is you're going to do when you set about this process. Now, I've listed at the front of the paper that I finally was persuaded to get in at the very last possible moment, the things that you typically might want to do on a discovery. And it's rare, in my view, that you would want, in fact, it's never the case in my experience, that you would want to do all of these things on one discovery. So it's important that you think about what your objectives are in terms of what you need to prove in this case. And it's, I guess I'd say, and I'll emphasize as I go on, keep your eye on the trial. This is not an exercise in conducting a perfect discovery. This is an exercise in winning a trial. To win that trial, you almost always will want to have the fact-finding function that I've listed as number one. And generally speaking, unless you're dead sure of the situation and all of the key facts that are likely to influence the outcome, you are going to want to find out the bad facts and the good. So you've got to sort of structure what you're going to do in that way. And generally speaking, unless the issues already have started out as being narrow, you're going to want to narrow the issues. The third purpose that's listed there, use as proof at trial, is one that we all give lip service to, but I wonder how often we really think about it as we're going through discovery. And what this really means is think about what parts of your discovery you're going to have to use for proof at trial because you really have no other way of proving the fact, or because this is the easiest way of proving it, some admission from the other side. Try and think about what those areas are ahead of time and structure your discovery in a way that will allow you to get a clear admission on those points. And Harvey's suggestion of sort of putting those cases, or putting those series of questions in the middle of an apparently innocuous group of questions is an effective way frequently of getting a good admission. But think about that. Think about what it is you want them to say, and think about how you can most likely get them to say that, and think about how it can be made clear in the transcript. And that usually means moving some of the more controversial stuff to some other place. In many cases, particularly where you're examining somebody with personal knowledge, but in any event, you'll want to lock in positions at trial, lock in stories for trial. And so you might want to get somebody pretty early on if the issue of whether their recollection is fresh or not is something you worry about. But that purpose is best served by making sure that whenever you get the story on the point, whatever it is, that you follow it up. Is there anything else? Is there anything else? Is there anything else? Though that is perhaps one of the most useful questions you ever ask on discovery, if you can remember to ask it. And almost all of us has 5 or 6 key examples we could give you where we forgot to ask it. We got caught up in the moment, we got caught up in the story, and we got an explanation that sounded not so bad or not so good, and we were happy with it, and we forgot to say, is there anything else? And 2 years later, when that witness is giving evidence at trial, you find there was. Evaluating key witness is not something you'll always want to do. You may not have the key witness. But if you do, you almost certainly will want to get a sense of how good is this person? How articulate is this person? How reliable is this person? Those are things you may want to do. In some situations, and you should have an idea before you go whether this is one of them, you may want to encourage settlement in a way that you've been unable to do by just dealing with the lawyer on the other side. And that's frequently the case. The lawyer on the other side may or may not realize the strengths and weaknesses of the case, but the lawyer may not have communicated those to the client, or the client may not have faced up to them. And in those circumstances, you may want to use the discovery as an opportunity to do 2 things. One, to have that witness really understand, because he or she's had to answer some questions, what the weaknesses really are, and also to get some personal taste of what the litigation process is all about. Now, I don't mean by this that it's appropriate, because in my view it isn't, to get a witness in the room and just go at that witness for days and days and days till they can't take it anymore. But I think there is a lesser process that many witnesses just haven't faced up to until they go to discovery. And it may be part of your strategy to spend a little more time on some of the tough areas for that witness, which invariably has to some extent a downside of educating the witness for trial, but may force the witness a little bit more clearly to confront the prospect of an advantageous settlement. The second last purpose is that you will, in some circumstances, want to use this as a basis for a motion, generally of an injunctive nature, or even more frequently, I suppose, of a summary judgment motion. For example, in the situation where the defense raised, you are the defendant, you've raised the limitation period defense, but of course you can't succeed on that until you know, under the current law, for example, and suppose it's a situation where the discovery period for the limitation period doesn't run until somebody has discovered something. In the absence of discovery, you may not know when the witness has discovered that the witness has a cause of action. So in those circumstances, you're going to want to use the discovery to tie down that admission if you can, with a view to moving for summary judgment. So think about that in advance. Think about whether there are any motions you will want to bring, and to structure the questions on those areas appropriately so that you'll get the information, and again, keeping the record in mind so that you can read that to the motions judge and be persuasive. The last point here is a tack on, if you really are worried that your witness is not going to be available, the witness is not going to be available for trial because of illness or whatever, you of course wouldn't rely on the discovery rules to enable you to use that evidence at trial. But under the 1985 rules, there is at least the prospect that you may do so if that unanticipated situation develops. So once you've done that canvas of the purposes of discovery, you're going to have some strategic choices that you have to make in structuring the conduct of your discovery. And I guess I'd say, and it harkens back to what I said at the beginning, if you think, and it is often the case, that one of the strategic issues for you on discovery is that you're not going to be a lint picker, as I call it, but you have an identifiable lint picker on the, or not lint picker, a lint vacuumer on the other side. And you often know that in advance or have reason to anticipate that that's so. There are things you can do that will structure the discovery process to avoid the opportunity for lint vacuuming. One is if you are acting for a number of plaintiffs with a similar interest. This is one of the reasons you would think of taking advantage of the new class action legislation, because it has a significant potential to collapse the otherwise enormous burden of production on each of the party plaintiffs and discovery of each of the party plaintiffs. You might also want to think about whether it's a case to ask for complex case management. But when you're going to do that, remember that he or she who lives by the sword dies by the sword. Before you do that, you want to be sure that you too can live with, in terms of the objectives of the discovery that you've just been through, a tight schedule and the possible limitations on discovery rights that might result. Then you want to think about who to examine. A key witness on one point who knows little about everything else, because you know that's a key witness and you want to find out what that witness's evidence will be like. Or somebody who has not a lot of first-hand knowledge about anything, but a lot of second-hand knowledge about everything and can pull the case as it is seen by the other side together better for you. And that's a decision you should make early on. When to examine? You might want to examine early if you want to force the other side to consider settlement earlier rather than later. You might want to examine early in order to avoid the other side doing any number of things that would educate them in the case, including reading your client's examination for discovery and suddenly seeing what it's all about. You might want to examine early if you want to lock the other side's story in at an early stage when either the recollection is fresh or you sense adequate preparation may not have been done. Or, of course, if you're the plaintiff and you just want to get the thing moving, you'll want to examine early. You may want to examine late if the freshness of the recollection is not really an issue. You may want to examine late, and you should not underestimate the advantage of examining after the other side because of the extent to which you may be educated about the other side's view of the case by listening to the examination for discovery that they conduct. It's often very revealing, and indeed that emphasizes a point I'll come to in a moment. When you are the hand-holding counsel, there are all sorts of things you should be doing, and the crossword puzzle is not one of them. You should be thinking about what it is that's prompting the questions that are being put to your witness, and what it is that tells you about the other side's theory. Another reason, of course, for examining late is you may want to put off the expense of examining late until you absolutely are sure the case is going to trial. And in situations where you're confident that the examination process isn't going to be followed by a long interlocutory discovery process, you might well want the advantage of not having to learn the case twice and therefore waiting and examining later. The style issue is one that's always interesting, and Harvey has alluded to it. I think it should never be underestimated how much you can glean from a witness by just chatting to them in a low-key conversational way. And they start to forget where they are, and they start to think they're at a cocktail party. And they start to get annoyed by the interruptions of this person on their left, and they really would just like to talk to you, and they do. And so I urge you to sort of think twice about the style and don't assume that by coming down hard and in a cross-examinational style that you may want to employ at trial, that you'll get as much as you could by just chatting, or seeming to just chat. On the other hand, there are going to be things that you really do want to tie down. There will be areas, or there may be, where you really want to chase the witness. You want to confront the witness with weak points in the witness's case and extract admissions, and that may call, particularly if there's interruption constant from the hand-holding counsel, that may call for a more confrontational and more aggressive approach. And in most discovery situations, you'll want a little of both, in which case you probably want to start friendly and go confrontational rather than go confrontational and start confrontational and go friendly. It's a little harder to sell the cocktail party chat after you've just browbeaten somebody into the ground. The order of topics is another interesting issue that I've seen people do it very effectively either way. There's no doubt that whatever you do, you should do exactly what Harvey's talked about in terms of thinking ahead of time of what it is you want to cover. And in many cases, the chronological topic-by-topic approach has an advantage. It has the advantage that for you, it's easier to keep all the balls in the air. It's easier to make sure you haven't left something behind. It's often easier to actually say, I'm now going to turn to the events of November the 22nd, 1993, and the date on which you signed the letter. And that makes it easier in lots of ways. The witness knows where you are. You know where you are. It's easier to go back when you're reviewing the transcript for trial. It may well be easier to read it in at trial if it's organized that way. And the witness may well be more forthcoming if the story is being elicited in the way that he or she is used to, beginning, middle, end. On the other hand, and this probably works better in the situation where you think you are facing a witness who has not been properly prepared, going entirely out of order will often work wonders. You will hear later this afternoon from my partner, Bob Armstrong, and I probably at this stage in his career I'm giving nothing away by saying he always starts with damages because almost nobody is ready for damages, except that he's now been doing it for so long that he's not probably getting away with it anymore. But in circumstances where somebody has, particularly where you're looking at 3 or 4 days of discovery, it's quite likely the person has come geared to deal with liability, and to hear about damages can sometimes result in volunteered evidence that you wouldn't otherwise get because the person just hasn't thought about it enough. So in that sense, I'd say the choice is between predictable and unpredictable, but I stress that the choice is not, in my view, between organized and disorganized, even though it may appear to the outside observer to be. Another strategic issue that flows from how you are proposing to use the discovery process is whether to cross-examine on discovery or at trial. And I think a useful way of thinking about this issue, and indeed a useful way of thinking about most of the discovery process, is to say, what do I want to say? I've looked at my case, I've done all the preparation that everybody has told us today we must do, and that almost none of us ever does to quite that extent. But I've done enough preparation to know that at the end of the day, this is what I want to say to the judge, and this is what I want to say to the jury. And then roll that back. Therefore, what do I want to cross-examine this witness on at trial, and what do I need now in order to be able to do that? For example, let's suppose you have a case where the action is one of misrepresentation against a director who has signed a prospectus. And he signed the prospectus that, let's say, it deals with the prospect of gold in a property owned by the company whose shares are being flogged. And that director is a sort of four-square sort, but he does know, or did know, 6 or 7 months ago before the prospectus, that there were rumblings within the company that some of the assay results on which all of these predictions were based were a little inconsistent and somewhat suspect. And you know, because of 1 or 2 memorandums, that he knows that. And so you know going into discovery that you want to say to the judge at the end of the day approximately the following, if you can. X was a director. He had a fiduciary obligation with respect to that company. He knew about that company's affairs. He knew that 6 months before the prospectus, there had been a question about the assay results on the gold property that that company owned. He signed the prospectus. He knew the investors would receive it. He knew that the purpose of the prospectus was to tell the investors what they needed to know. He knew that the purpose of the prospectus was to make sure they had all the material facts. He knew that any reasonable investor would consider that this was a material fact with respect to that gold property. And he made, when he signed the inquiries, signed the prospectus, no inquiries of the geologist to find out how this apparent discrepancy had been resolved. He didn't read the geological reports. He didn't do this, he didn't do that, he didn't do that. He signed the prospectus, and in the result, he knowingly failed to disclose a material fact to interested investors. That's what you want to say to the judge. And all of those is, in fact, points you will want to draw out in the cross-examination of that witness at trial. So what do you need to do on discovery to do that? And that's where you turn it around, I think, in at least the first instance and ask the open-ended questions. Some of them are open-ended, some of them aren't. You establish that he was a director. You establish that he knew about these facts 6 months ahead of time. You ask him what he did when he signed the prospectus. You ask him who he talked to before he signed it. You ask him why he signed it. You do all those open-ended questions. And then the strategic question is, do you turn that in to a cross-examination at discovery? Do you put to him the propositions that emerge from your open-ended questions? And the answer to that is it depends on the case. The difficulty, to the extent that you think there is any wiggle room, that the witness might wiggle out at trial if you don't do it, you'll be driven to do it. To the extent that you really want to cross-examine this witness at trial, you probably don't. If the witness has any sense at all, it's very rare that you'll get 2 good cross-examinations out of the same witness, and you probably want to leave it for trial. But it's an important issue and one you should think about when you're conducting a discovery. The other thing that you should think about when you're conducting a discovery, and we all give lip service to it, but I know I frequently fail to do more than give lip service to it, and I have observed other people make the same failing. Create a record for trial. Think about what this will look like when you read it to the trial judge. And there are a number of things that flow from that. You should, generally speaking, be avoiding buzzwords and shorthand. And that's a very common failing. You sort of get into this cocktail conversation with the witness, and you both know what you're talking about, so you forget to make it explicit. You say to the witness, oh, well, you signed the 1075 and you passed it on to the VP of XWO. Now, what you want to say at trial is the 1075, which you know, and the witness knows, but nobody on the discovery transcript has said, is the document in which, in his corporation, he is supposed to set out every material fact with respect to this transaction. But you could read the discovery from beginning to end and not find that. And yet it's key to what you want to read into the trial, at trial. Keep that in mind. No buzzwords, no short forms. Isolate the clear admissions that you want from the areas where you may get into some difficulty. In the case that I just talked about, some things you know you'll be able to establish. You want to get the admission that the guy was a director, that he signed the prospectus, that he read the certificate that says it was full, true, and plain disclosure, that he knew it was being done for the purposes of investment, that he knew it would go to investors. You probably put those questions in one part of the transcript, and at some other part of the transcript, hopefully many pages further on, where nobody will think to look at, and no one will say, gosh, you've got to read those questions with this question. You'll say, why did you do it? You don't want to ask that question back with the questions that you're going to read in at trial, because you know he's going to have some, by the time he gets there, if he's got a lawyer that's anywhere worth his salt, he'll have some explanation for why he did it, and you don't want to have to read that in. Oh, the president was the best geologist I'd ever known in my life. I'd never known him to make a mistake, and he didn't make one now. You don't want to know that. You don't want to read that, and you don't want that to be part of your case. So if he's going to tell you something like that. So move it as far away from the admissions as you can. The other thing, a lot of what takes place in the room is nonverbal, and it certainly affects the dynamics of what's going on to the transcript. And to the extent that you can put that on the transcript, if it's helpful to you, think about doing so. If you're the examining counsel and the witness has been asked a question and is only able to answer it because his counsel has stuck the document in front of him, record that. If the witness is losing his temper, or his counsel is, and is screaming at you, say, Mr. X, there's no need to scream. Mr. X, there's no need to climb over the table at me. Mr. X, please sit down. Or if Mr. X is, as some, I recently had a case actually, there's a video which many of you will have seen, which increasingly witnesses are shown, which tells them how to be good witnesses on discovery. And it says, wait for the question to be answered. Think about the question. Think about your answer to the question. Maybe jog down 1 or 2 points you wish to make. This witness had had that lesson in spades by one of John's partners. And he did that, and he listened. Then he demanded any clarification, and then he wrote out his answer. And the fact that I was actually the third counseling examining, so I'd had a chance to think about this. Other people had recorded the fact that he was writing down his answer, and it sort of didn't discourage him at all. He kept writing down his answer. So I asked the reporter to start recording. The reporter did what the reporters often do. They turn the tape off while the witness is thinking about it, because it's easier to type a transcript if the typist can just not have to listen to sort of 20 minutes of silence, which is what those of us in the room were listening to. So I asked the reporter to keep the tape on and to record the time, that the tape was on for. And the guy stopped writing down his answers within about half an hour. The advantage of all of these things is that you either do one of two things. Either if it affects if it detracts from the evidence he's given, if it were known to the trial judge, recording them in the transcript makes sure that it is known to the trial judge. The other thing is that it will frequently discourage the conduct that is kind of deflecting your examination. People stop shouting, they stop sticking documents in front of witnesses when they shouldn't be, and by and large they speed up. You should think about naming things, and naming things consistently, for two reasons. One is we are inevitably into the field of, into computerization of transcripts. And if you have a consistent way of referring to something, your computer can pull that thing up in just with a word search. So you might say, if there are in my old prospectus case 3 prospectuses, the first prospectus becomes the prospectus of May the 27th, 1991, and you always afterwards make a point of calling that the first prospectus. Or if somebody else refers to it, you put in, oh, you mean the first prospectus. That way the search is easier. But perhaps more significantly is to think about naming things in ways that are favorable to your case. Recently, I sometimes chair discipline proceedings at the University of Toronto, and there was one case recently that probably went further than it should have in this vein, but essentially the theories were, on the one hand, that a student who had copied 95% of his essay from a series of texts had engaged, and without quotation marks, although some reference to where it came from, had engaged in plagiarism. And the defense was he had engaged in research. And putting aside the merit of characterization of research at that point, clearly, if you were conducting the discovery in that case, you might think about, as the prosecuting counsel, always calling this piece of work the piece of plagiarism. That's probably actually going a little far, but it tends to make the point. Whereas the defense counsel would be thinking in terms of calling this the piece of research. Think about what you're going to call things and try and think of names for things that will be consistent with the speech you want to make to the judge at the end of the case. The last thing about creating a record is to be very wary of off-the-record discussions. They are engaged in all the time, and generally speaking, without too much downside. They should be conducted on the basis that all parties understand that it is truly an off-the-record discussion, and you don't come back on the record and immediately repeat, without the consent of everybody, what's been said. Unfortunately, not all counsel live by that rule or appear to be aware of it. So particularly in the situation where you're dealing with somebody whom you don't know is familiar with that practice, you should be wary of it, but also be wary of the fact that even if that counsel is, his or her witness may not be. So only go off the record if you have to, and make sure that the rules for going off the record are expressed before you do it. The other disadvantage is that frequently you hear things off the record that you don't want at all to be off the record. And it's sometimes difficult to get them back on the record if you've taken my first piece of advice, and that is made sure that everything that's off the record is off the record. Questioning techniques, let me say in view of the time, are some of the things that have been covered already. Make sure your questions are clear and short and will be read back well. If you ask a witness a question along the lines of, and then after you spoke to X, you went back to your office and you wrote a memorandum in which you reviewed A, B, C, D, and D, and then you filed it and you didn't do anything more for another 2 years when suddenly you remembered, and then you did Y, didn't you? No. Well, you can see the problem, particularly if you leave it at that, as many people do. Make sure the question is short, that the answer clearly relates to a specific part of a short and unambiguous question. Think in terms of asking, particularly when you're in the information gathering mode, of open-ended questions. If you say, because you think you know, and then the next thing you did was you wrote this memorandum, you may get a yes. And if you'd said, and what did you do next, you might get the infinitely more interesting piece of information that I talked to X, who told me I should be very careful to take a very discrete view of this incident and record it in a way that made clear that the following had happened. And then I had a further conversation with W because it was so significant to our company, and then I wrote the memorandum. You want all of that. You don't just want your preconceived notion of what the information is going to be. Always remember the close-off questions. After the witness has told you what the witness did you do anything else about that? And lastly, have a plan. Don't necessarily be wedded to the plan. A key for good discovery is to listen to what you're being told. Be ready for the unexpected. Make a note of it. Go with it then if that seems best. Follow it up then. But if you don't, mark and come back. And on the other hand, don't let a series of very good questions which take you off in one direction make you forget to come back to what the other things are that you want to cover. I've given you what, in relation to what Harvey has given you, is a much shorter list of checklists to consider in terms of things to cover on discovery. On page 4, there's a reference to some of the things that you would want to deal with in respect of documents. My only caution there is don't be wedded to the documents. They often will be a very important springboard for the oral discovery you want to conduct, but don't assume that everything that's important in your case will be reflected in the documents. It often isn't. And the other thing is, while you will want to be exhaustive in some of the ways I've suggested here with respect to important documents, think about whether it's really necessary to do that with all 1,000 that have been produced by the other side. It almost never is. Documents are the one area, it seems to me, that more than any tends to invite the vacuuming of lint when it may not be very productive. Think about whether you're in that situation. If you have key conversations, think about covering the subjects that are dealt with on page 5. And remember that you do have the right to get information from other people who are not in the discovery room, and I make some observations on page 6 about the appropriate range of that. Think about whether expert evidence is likely to figure in your case, and consider what information you are entitled to. A great deal of information in the possession of experts now, or that may be in the possession of experts yet to be retained, and make sure you've covered those off in your questions. Insurance and pleadings are things that Harvey has talked about. I think it's important when you are the hand-holding counsel to take an active role in the proceedings and to do many of the things that I've suggested starting on page 7. The classic rule that we've come to hear is that, in fact, I've seen it now in cases, hand-holding counsel are not potted plants, therefore maligning some very nice forms of life, but it isn't what you're supposed to be doing in a discovery room, and you should be careful to keep track of the list of things you should be doing, preserving and clarifying the record, the mirror image of what the examining counsel wants to do. Protect your witness appropriately, even if you've got a good witness who can probably deal with anything that comes at him or her. Make sure that he or she doesn't have to if it's irrelevant, or if it's repetitive, or if it's speculative, or if it goes beyond the realm of relevancy. The fact that the witness can handle it is not a basis for making the witness do so. Think about whether your witness is in need of a break and make sure that the witness gets it, if he or she is. Think about undertakings. Don't give them unless they're necessary to the case and appropriately asked. Don't give them about things you don't yet know. The most you'd want to do is undertake to look for and look at something and advise whether it'll be produced. And if you are the examining counsel, you might want to try and make sure that you know what will be done to satisfy the undertaking and list all the things that in addition to whatever general inquiries might be made, you want the witness to look in X file and W office and ask, speak to Z, and so on, so that the key areas are covered. I've mentioned in here something that rarely comes up, but you should think about. If you are the hand-holding counsel and your witness has said something that you know is incomplete or inaccurate in a way that's important to your case, generally speaking, you'd want to try and insert a clarification or an explanation right then. And in many situations, you'd be allowed to do that because the other side may want to hear that then or later. But if that doesn't happen, and if the information is important to your case, you may consider re-examination. If it's an important area, a letter that arrives in the counsel's office 2 weeks later and says, or 4 months later, we reviewed the transcript and would like to correct the answer on page 10, often has a lot less impact than a clarification that is in effect provided by re-examination. It rarely happens. It rarely should happen, but think about whether you're in a situation where re-examination is appropriate. I've given you some of the cases to which reference has already been made that set the bounds of the kinds of interruptions and discussions that hand-holding counsel can engage in. Just alert you on page 9, the cases that have dealt with the extent to which you can talk to your witness on discovery in Ontario indicate that you can't do so as a prelude to the witness answering the question or for purposes of coaching the witness in answering the question, but that in appropriate breaks you can have whatever ordinary conversation with the witness you might in any event have. In British Columbia, and that's the last case there, Fraser River, the rules of professional conduct have been interpreted by the courts, and they have now given guidelines that say, in essence, you shouldn't discuss the case with your witness while your witness is being examined for discovery. An interesting view of the way things should be, which I suppose we may find being considered in here. I should say there is a caveat on that, and that is if the discovery lasts more than 1 day, you're entitled to deal with the witness, and even in BC, for purposes of answering undertakings, discussing settlement proposals, and so on. If you are the non-hand-holding counsel and you're having some difficulty with the hand-holding counsel, think about whether the proper approach is just to fight back, which in many cases it is, or to just quietly persist, or to try and persuade the examining counsel. And sometimes if you point out the lack of reasonableness of the position on the other side, sometimes with, as Harvey says, the case that says you're right and he's wrong, a number of things happen. He starts to look foolish in front of his client, or he or she is looking at the possibility of cost sanctions down the road, and they may be persuaded to come to a more reasonable view of things. So don't assume just because there isn't a judge or a presiding officer that there's no room for persuasive tactics with the other side. Remember, when you have been confronted with a hand-holding counsel who is obstreperous, interventionist, and talks too much, not to be deflected. And that's very, very hard, because what typically happens with such a person, I of course have never been such a person, is that you ask, for example, in my prospectus case, you knew that that prospectus was going to potential investors, didn't you? Well, how could he know that? That's speculative. He didn't know. I mean, what go on and you fight back and forth for 2 pages, your blood's running, your adrenaline's up, you're mad as hell. 2 pages later, he says, oh, all right, go ask your question. And you forget what it was. Keep a note of it, go back to it, don't get deflected. I've made a couple of observations about things that you'd want to do in closing. I just point out, make this one further suggestion. The obligation to continue to answer undertakings, to deal with well, not to deal with objections, but to advise of positions on objections, and to provide continuing discovery is now clear, and it's in the rules. And I think a lot of people will just say, well, it's there, I don't need to say anything about it, and that's probably true. But I have increasingly developed a practice of saying to the witness, now you understand that the law requires that if any more documents come to your attention that are relevant in any way to this action, or that if you learn that anything you've told me is wrong or not complete, or that you learn of anything additional, do you understand that the law requires you to tell your counsel so that he or she can tell me? And that way, you avoid the situation that I have otherwise seen happen, which is the obligation is there, but the client knows nothing about it. And so when the matter surfaces that should have come out as a result of the obligation for continuing discovery, and you hear about it for the first time at trial, the witness says, well, I'm sorry, I just didn't know, and the judge lets it in anyway. If you've gone through that drill at the end of the discovery, that's much harder to do. So I suggest that you think about that. But let me say in closing that all of these things are things that I merely suggest you think about. They are not at all things that everybody should do in every single discovery, because even though we are under a lot of attack and a lot of legitimate attack as a profession, I don't think we are, and I don't think we think that we are, lint vacuumers, and we shouldn't conduct ourselves as though we were. Thank you.
A psychologist once said that one of the most evocative words a questioner can use, which will sometimes open a floodgate of response, is, and what did you feel about that? What did you feel about that? If you say to the witness, and what did you think about that, opposing counsel will object. Sometimes you can slip in, and what did you feel about that? And you'll get wonderful answers. Okay, discovery's over. You walk out the door, you think your job is finished. It isn't. There's still a huge amount of follow-up. And to tell us about it, there are two types of leading counsel. There's counsel that all members of the profession would say he's one of the greatest and the public has never heard of. And then there's a name that's on the lips of every member of the public. John Laskin is both.
Harvey really meant to say was there are two kinds of counsel. There's those counsel that like to do their own discoveries, and there's those counsel like me who can't stand doing discoveries and do everything they can to avoid them. So here I am talking to all of you about the discovery process, and I think this isn't meant by way of false praise at all. I think by listening to Harvey and Patricia, you can ascertain very quickly why they are two of the very best examiners that I personally have ever seen conduct discoveries, and they are two of the toughest adversaries to have in litigation. My role in this process is a rather small one, but perhaps deals with a subject that is important, and that is what about the discovery process after the examinations for discovery have been completed. And I would like to talk to you briefly this afternoon about two aspects of that. Number one, the continuing obligation in Rule 31.09 to correct and complete answers given on discovery, for which we may all be thankful or not so thankful to Patricia. And secondly, the qualified right to examine non-parties under Rule 31.10 as part of the discovery process. And when I finished talking about that for a little bit, I did want to spend just a few minutes giving you a couple of observations about something I guess you've heard a little bit about today, and that is the recent cries from some quarters to reform the discovery process. Seems a little odd to me that on a program devoted to doing it fast and doing it cheap, I am here talking about two rules which, at least on one view, result in doing it slow and doing it expensive, and that is Rules 31.09 and 31.10. both of which, as I expect most, if not all of you know, came into our practice with the reform and overhaul of the rules in 1985. They were part of a series or package of amendments that were designed to broaden discovery. The trick, I think, is to apply those rules and use them in a way that they do not become so burdensome that the burden and cost of the rules outweigh their benefits. My sense is, and particularly in respect of Rule 3109, my sense is that litigators, as a general proposition, are not all that vigilant or aggressive in either fulfilling their 3109 duties or in pursuing their Rule 3109 rights. And it may simply be the fact that we are not yet all that used to the rule, because the reality is that a lot of information, and all of you know it, a lot of information comes into your possession after the discovery has been completed. Be that because that's when you finally start to do your investigations, or that's when you start talking to people who know something about the case, or whatever. And because of all of that, it seems to me that Rule 3109, which I will talk about first, has some particular significance to the discovery process. It does mandate disclosing after acquired information that either corrects or completes an answer previously given on discovery. And like an ordinary coin, like a 25-cent piece, Rule 3109 has two sides, and I guess it depends on what your perspective is. From the perspective of the examining party, it of course provides a continuing right to know. From the perspective of the party being examined, it requires a continuing obligation to disclose. And I would like to spend just a few moments talking about the practical implications from each perspective in terms really of cost and burden. Because it seems to me that there are some very simple things you can do to take advantage of this rule on the one hand and to fulfill your obligations under it on the other without unduly burdening your litigation. So let me throw out a couple of suggestions. Let me begin, first of all, by looking at it from the viewpoint of the examining party. The first, and it seems to me by far the most important point about Rule 3109, is that you have to lay the foundation back in the discovery. And you have to do all of the things that Harvey and Patricia so eloquently and articulately put to you. And the reason for that is that you don't have any Rule 3109 rights unless you ask the right questions on discovery. There is not, and there may be some confusion about this in the profession, but there is not any general obligation on a party to disclose after acquired information. The duty only relates to specific questions asked on discovery. So if you want to take advantage of the rule, you've got to make sure you ask the right questions. I doubt very much that a court would uphold your right on discovery to insist on a general undertaking from your opponent to disclose generally after acquired information. And so the question is, how do you protect yourself and how do you ensure that you trigger the duty? And I think it's not all that difficult to do it quickly and do it simply. If what you want to do is ensure that you know the case you have to meet and you want to avoid surprise, then it seems to me all you really have to do on discovery is make certain you ask the closing questions that Harvey and Patricia talked about. Have you told me all of the facts upon which you rely in support of each allegation in your pleading, and take the witness through each allegation in the pleading? That was something that I was taught to do when I was an articling student by Walter Williston. It never ceases to amaze me still how many counsel forget or neglect on discovery to ask those general, simple questions which at the end of the day protect your position, and particularly now in relation to Rule 3109 become very significant. Well, of course, there's another main object of discovery, and that is, of course, to find out what your opponent knows that will help your case. And it seems to me that, again, all you have to do is put, very simply, your theory of the case to the person you are examining. Ask him what facts he has or what information he has in his possession that bears on your allegations. Or try a question like, Mr. X, what information do you have that contradicts or qualifies the allegations in your own pleading? Okay. Second, you can use Rule 3109 in conjunction with other rules. And by far, to me, the two most important rules to use in conjunction with Rule 3109 are Rule 3106 sub 2, disclosure of the identity of persons with knowledge, and Rule 3106.3, disclosure of the findings, opinions, and conclusions of experts. And if you make sure and remember to ask the 3106.2 and 3106.3 questions, then you have essentially preserved for yourself the right to know subsequently the identity of other persons with knowledge, subsequent changes or corrections in the findings, conclusions, and so on of your opponent's experts that may be called as witnesses at trial against you. It is interesting that in the United States, and Rule 3109 was modeled on a rule that came from the U.S. Federal Rules of Civil Procedure. In the United States, they have found that by far the most important use of their equivalent to Rule 3109 has been to ferret out what would otherwise be the surprise witness for the other side at trial by asking specifically a question that triggers a response akin to a response to Rule 3106.2. Now, third point that I throw out to you is that subsequent disclosure of after acquired information that corrects or amends an answer given on discovery does not eliminate the previous answer, of course. And therefore, you as an examiner, it seems to me, should be alive to the real possibility of impeachment that has been given to you by a Rule 3109 disclosure. And I think, to make life simple, because I can never remember if I get a subsequent 3109 disclosure, what question it relates to in the transcript, it seems to me as a mechanical process, or at least it works for me, you've got to line up the two answers side by side so that when you get to trial, you've got answer A given on discovery and you've got answer B subsequently disclosed after the fact, so that you can then have the possibility of impeaching for inconsistency. And in that connection, do not be content or do not let your opponent get away with sending you a correcting answer through his counsel. Don't be content with the counsel's letter, oh, well, I've now got some other information that corrects my client's answer given on discovery at question 226, and here's a correction or here's an amendment. You're entitled to insist on the answer from the client, from the person being examined. You don't have to accept the counsel's answer, and it seems to me that you run the risk, if you simply accept a letter from the lawyer, that you're not going to have a very effective record for impeachment purposes. Indeed, I would go farther and suggest to you that if the answer is, in your judgment, very significant or could be very significant at trial, insist on your right to have the answer verified by affidavit under the rules, which you're entitled to do. Finally, if you're going to make effective use of this rule, you need to be familiar with the transcript that's been conducted of the other side, or if you did it yourself, to remember it some 5 or 6 months later, or a year later, or a year and a half later. Not so easy. If your memory's as bad as mine, I have finally got in the practice of summarizing my discoveries, at least in any reasonably significant case. And I highly recommend that to you, and I highly recommend that while it may take a little bit of time when you do it, that you do it yourself and not assign it to a law clerk or a student. Because quite frankly, a summary done by someone else is not nearly as helpful to you as a summary done by you. It, at the end of the day, will save you, I expect, an enormous amount of time and cost. And if you've got the summary, then you've got an effective way of figuring out whether, when you come to trial, evidence led by your opponent is in fact undisclosed information, in contrary to Rule 3109. You can't very well exercise your right to ask for the sanction of excluding the evidence if you don't know that the evidence should be excluded because it was subsequently not disclosed. So I suggest that you consider making those summaries. What if you know, or at least suspect, that your opponent is not fulfilling his Rule 3109 obligation? Do you simply have a knee-jerk reaction and fire off a letter to him demanding disclosure of the information? Maybe. But before you so quickly get that letter out, you may want to think about whether the information is going to help you or hurt you. Because if the information is likely to hurt your case, you may not want to ask for it. You indeed may want to sit back, and if your opponent then comes to try to elicit the evidence at trial, you may want to stand up and object that the evidence ought to be excluded. But before you take that position, you better make sure that on discovery you ask the question that would have triggered the Rule 3109 obligation in the first place. Well, let me turn it around for a minute and talk about Rule 3109 from the viewpoint of the party being examined. And I suppose the first and most important point is that Rule 3109 imposes some obligation on you as a lawyer to be familiar with your client's discovery. You can't very well tell the trial judge in the middle of the trial, yes, this was subsequently acquired information, but I didn't know about it because I didn't know what my client said on discovery. Not likely to be a very persuasive argument to the trial judge. So here again, I personally am a big believer in having a summary of the transcript of evidence in any case that can reasonably afford it. Do you have to read and reread your transcript every time a new piece of information comes in? I mean, I guess the question is, how far does this duty go? Our courts haven't been very clear about how far the duty goes. One would hope that the court doesn't read into the duty something that would make it so onerous and so burdensome that it would really defeat the benefits of the rule. It seems to me that the obligation should certainly apply in respect of significant after acquired information, significant information or relevant information to a material issue in the action. When you go down the line, it surely, I would not have thought, means that you must disclose every little tittling piece of information that comes to your possession after, and your knowledge after discovery, no matter how insignificant it is. But I guess the bottom line is that you have to err on the side of disclosure, especially if you're intending to lead some of that evidence at trial. And again, that's why I recommend a transcript. The rule says you've got to disclose it forthwith. I don't know what forthwith means other than immediately, but I expect the court would give you some leeway if you disclosed it at least in time to give your opponent a sufficient time to consider the disclosure and respond appropriately. Let me move from Rule 3109 to Rule 3110, which is, of course, the qualified right that we now have to examine non-parties. And as we all know, our rule makers looked at the American experience, which gives an automatic right to examine non-parties, backed away from that, and qualified it by saying we need to get leave, and more importantly, the court's discretion in granting leave is structured under the rule itself in which the criteria for granting leave are set out. The requirements are cumulative, and I would suggest to you that generally, notwithstanding some early case law, the threshold is quite high. And it's certainly my view that Rule 3110 orders should not, and indeed are not, routinely made. And so the bottom line from that is don't abuse the rule. Make sure you really need the evidence, because at the end of the day, Rule 3110 can be a very costly procedure. Now, if you are going to seek an order under Rule 3110, one of the important things you need to do is take a lot of care in drafting the affidavit in support of the motion. And you have to make sure, although it seems obvious and commonplace to say it, you have to make sure that your affidavit addresses each branch of the test and also addresses why the deponent of your affidavit has reason to believe the person sought to be examined has information relevant to the issue. It may be that a person you seek to examine is a person who was identified to you under an inquiry under Rule 3106-2. But let me caution you to say that simply because a person has knowledge under Rule 3106-2 does not automatically make that person a candidate for an order under Rule 3110, which I treat as being much narrower and having a much more stringent test. Second, and I guess this is why I am talking about Rule 3110, as a practical matter, there is no sense, in my view, in bringing your leave motion, if you're going to bring it at all, until you've completed your discovery, and not only completed your discovery, but have given your opponent a chance to provide you with the information that you now seek. Because you know that the key requirement of the rule is that you can't obtain the information you're seeking from persons you are entitled as of right to examine for discovery. And because of that requirement that you must meet, if you are going ultimately to seek a Rule 3110 order, you've got to lay a foundation on discovery. So you've got to ask on discovery for the information that you may ultimately seek from the non-party. And you've got to put the questions on discovery, even if it involves an undertaking. You've got to ask for the undertaking, and you've got to give the other side an opportunity to meet the undertaking. The result of all of that, of course, is that the person you are examining, or your opponent in the case, can avoid an order under Rule 3110 by providing you with the information secondhand, as it were. And it seems to me that when all is said and done, the one thing that Rule 3110 does not give you is a right to examine a non-party and get his evidence firsthand. You have to be content, I think, in almost every case, and there are some cases which suggest otherwise, and I'm not sure they're right. I think you, in almost every case, will have to be content with a second-hand version of events if that's what your opponent gives you. Don't overlook the need to demonstrate to the court on the leave motion why it would be unfair to proceed to trial without the examination of the non-party. There hasn't been a lot of case law to date on the requirement to show unfairness, but it seems to me that our courts, in an effort to try to curb the expanding discovery process, may well get into the business of deciding Rule 3110 motions on issues of unfairness. And one of the things that I think the rule highlights is that the information that you're seeking to acquire from the third party needs to be central to the case. I mean, it has to be significant and central to a main issue in the litigation. So those are just a few brief comments on Rule 3110, and I just want to change horses or topics for the last few minutes of this talk and talk to you a little bit about the discovery process and whether indeed it is time to relook at the discovery process, because rather than enabling us to get the facts fast and cheaply, it seems to be doing the opposite. And I guess, because others have said it, I will be brief about it, but I think it's worth drawing to everyone's attention that there is indeed a growing concern over the discovery process that is coming not just from some members of the bar, but much more importantly is coming from a lot of members of the bench. And there is a strong feeling amongst a number of our trial judges that the discovery process is being abused. And while there is a legitimate concern about the escalating cost of litigation, what we are now hearing more and more, and I think with increasing legitimacy, is that most claimants have abandoned the system because they can't afford the system. And that has caused an obvious response from judges and from senior members of the bar. And I think we as litigators have to be conscious of that and responsible in looking at our own way in which we conduct discoveries, and indeed looking at the discovery rules. When judges talk about the unnecessary costs of litigation, they invariably finger unnecessary discoveries, unduly long discoveries, as the main culprit leading to that cost. A good deal of the evidence that is cited to support the contention is obviously anecdotal. There is not a good lot of empirical evidence one way or the other, and quite frankly, I'm not here to plead the case for or against, but simply to say as litigators that we need to be conscious about it. Some have alleged that a main cause is the rule permitting cross-examinations, and there have been cries from some quarters to relook at that rule, which came in 1985. I'm not sure from my own limited experience that the rule against cross-examination should be cited as the main culprit. Others say there is no abuse, or if there is, that it cannot be cured by reform of the rules. And if you talk to some people, they would place the blame at the feet, first of all, of the economics of large law firms and the targeting billing rates and docketing rates and so on of young lawyers in those firms. Others would cite the fact that lawyers are now afraid of being sued, and so in fear of being sued for doing a job badly, they ask more questions rather than less questions. Others still have argued, and there are some judges that are very strong on this, that we would cure the discovery process if we had a case management system that allowed for much earlier intervention by a trial judge, and Trish Jackson's paper has a little bit of the comments about involvement of trial judges and so on in case management. Again, I'm not here to argue the case one way or the other. I do want to tell you quickly about two initiatives which are being undertaken and which I think Eleanor may have mentioned this morning, since I have some involvement in both of them. The first is the initiative by the Ministry of the Attorney General, and I think that's quite a serious initiative. There is a committee which we have called the Simplified Rules Committee, which is designed to address the question of discovery in smaller cases. By smaller, I mean cases involving less dollars. And the proposal that is being currently floated by that committee and has been taken quite seriously by most members of that committee is to fix an upper limit, be it $50,000 or $100,000, and to have a virtual blanket exclusion of discoveries with perhaps a small safety valve for exceptional cases. The safety valve would be for the small case that may have precedent value and implications down the line. But the thought would be that there is no point having discovery with leave, because the result is just going to be a a series of motions to get leave to examine for discovery. You have to have a virtual blanket rule. If you don't have a blanket rule, the system won't work. And so the thought is, insist on affidavits of documents, have sworn will-say statements, but no discovery. And if you think about it, there are many administrative tribunals around this province which have functioned very, very well with just such a system for many years. And I guess the thought is that at the end of the day, there has to be a trade-off between the benefits of perfect knowledge that you might get from discovery against the costs of litigation in small cases. But you will hear a lot of concern by a lot of judges that there are just too many people now excluded from the system. The alternative, I suppose, would be some form of time-limited discovery, which has been tried in some jurisdictions, where you get, I guess it depends on how quickly you ask questions, but you get an hour and a half for discovery, or you get 3 hours for discovery, or whatever. In any event, that is one initiative that is going on right now, and I think is likely to produce some reform in our rules governing discovery in less substantial cases from a monetary point of view. Of course, you always run the risk that somebody's $25,000 case may be significantly important to that particular person, notwithstanding that it comes under whatever monetary threshold you're talking about. But again, it's a trade-off. The second initiative that's going on is a general review by the Advocate Society, which focuses more generally on the discovery rules and the rules regarding motions. There is no clear consensus, I think, amongst members of the Advocate Society that the rules need reforming, but we are looking at those rules. And for my sins, I'm supposed to be trying to run that subcommittee, and I leave you simply with this, that if any of you have any suggestions about discovery or motions, don't be shy. Drop me a letter. Many people have, and a lot of people have suggested some very sensible things. So, Harvey, thank you for inviting me onto this, and thank you for your attention this afternoon.
John's comment about a précis of discovery. I need a précis because, as you know, I'm computer illiterate. I'm told that people who operate a computer hands-on don't. They'll work right off the screen and don't need a précis. I personally don't know. But I find it convenient to dictate the précis that evening. I come back from discovery and I dictate from my notes. I have very extensive notes. If I'm the examiner, I've got my whole script, and I can tick off the answers right onto my script. If I'm being examined, I take extensive notes. You may think it's a waste of time, but it means I can dictate my précis that evening. Then when the transcript comes in, my secretary will convert my précis to a transcript précis. That is, she will go through the transcript and input the page numbers into my précis. I find that very useful. I do two other things during the examination. I make a list of undertakings and objections, and I make a list of key points. They might be right on my notes, or they may be on a separate pad, and I dictate those separately. So I can get working on following up undertakings immediately. My secretary can, because I've dictated it and she follows it up. And then when the transcript comes in, again, you can input the question numbers. You cannot rely on the examiner's summary of undertakings and objections. Most examiners now will give you those couple of pages at the beginning. You can't rely on them. They're not complete because they've got to pick up the key word. I undertake to do so. I object to that question. So someone's got to go through the transcript, use it as a draft, use my memo as a draft, put the two together, and make a complete list for follow-up purposes. 10 minutes, back at 3:25.